Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, listen, a couple of weeks ago, I did a video where I accused someone on GunBroker, a person who goes by the name Rifle Remedy 2000, of being an ATF account. Now, as it turned out, and I want to make the record clear, I was dead wrong about that, and I did post a video the very next day where I corrected the record. I hope that most of you have spread the word. Now, when I mentioned it the first time, though, that I was concerned that the ATF did have accounts on GunBroker, I was serious about that. And I did believe, and I still do believe, that they do have GunBroker accounts. Now, I believe the primary purpose of that, of course, is to monitor things. But what if they were actually out there selling things? A lot of you people were concerned that they might have been, and you screamed right away, hey, that's entrapment. Is it really? Well, I don't know. Let's spend a few minutes today and talk about, did the ATF entrap people by selling FRT triggers and solvent traps? Okay, before we get going down the road we are going down, proud to announce that this video is being sponsored by Legal Heat. That's right, the nation's largest educator of concealed carry classes. Legal Heat has taught over 200,000 people nationwide since they started business in 2005. Now listen, for my Washington viewers, you can find a class at any one of these locations right here. If you're watching from somewhere outside of the state of Washington, congratulations. You are probably living much freer than I am. But you too can find a class right in your own backyard if you visit them at mylegalheat.com. That is mylegalheat.com. Now listen, for everybody, no matter where you are, People's Republic of Washington or somewhere else in a freer United States, if you use the promo code Washington Gun Law, that's Washington Gun Law, all one word, you will receive 10% off any class that you sign up for. So once again, for more information, visit them at mylegalheat.com. Okay, so as an attorney, and we do this a lot in law school, and we kind of live a life of what's called living life in the hypothetical. And so we are going to have a hypothetical discussion today. And the hypothetical discussion is, let's say the ATF really did have GunBroker accounts, and let's say the ATF was now selling FRTs, wide open triggers, solvent traps, and any of the other contraband that the ATF seems to be hot to trot on right now. Many of you believe that, well, if they did that and somebody purchased it, that would be entrapment. Are you correct? Is that in fact entrapment? The answer is, in all likelihood, no, it's not. And I know right now a lot of you like, how can that possibly be? Well, today we're going to geek out a little bit, and we're going to talk about what is entrapment, what really constitutes it, and how does it work. Now, entrapment in general is an affirmative defense. It's like self-defense. It's like necessity. And what an affirmative defense is, yeah, I did it. I committed the act, but there is a legal justification or a legal excuse for my commission of that act. And if it's proven by preponderance of evidence, and then the prosecution fails to disprove it beyond a reasonable doubt, a jury is instructed to find the defendant not guilty by reason of that affirmative defense. Let me give you a little bit of case law that kind of helps better illustrate what exactly is entrapment. Take a look at, for example, Jacobson versus the United States, which stated, entrapment is a complete defense to a criminal charge on the theory that government agents may not originate a criminal design, implant in an innocent person's mind the disposition to commit a criminal act, and then induce the commission of the crime so that the government may prosecute. And yes, I know that that sounds exactly like the ATF's MO, but carefully pay attention to what the actual case law says. A valid entrapment defense has two related elements. One, government inducement of the crime, and two, the defendant's lack of predisposition to engage in the criminal conduct. Of the two elements, predisposition is by far more important. So that's the most important thing. The mere fact that government is trying to induce a person into criminal conduct does not in and of itself constitute entrapment. It only constitutes entrapment if the criminal perpetrator, the person who was induced, had no predisposition to committing that crime. But listen, the law actually allows law enforcement to actually go a little bit beyond even inducement. Take a look at what the case law says. Inducement is the threshold issue in the entrapment defense. Mere solicitation to commit a crime is not inducement, nor does the government's use of artifice, stratagem, pretense, or deceit establish inducement. Rather, inducement requires a showing of at least persuasion or mild coercion. So yeah, trickery, deceit, any of that, that still doesn't rise to the level of entrapment. What the case law is saying here is that you basically have to coerce the individual into committing the criminal act before it rises to the level of entrapment. And it is that inability to establish the lack of predisposition where most entrapment defenses fall short. The case law goes on to state, and this is one of the reasons this is a very difficult defense, even if inducement has been shown, a finding of predisposition is fatal to an entrapment defense. The predisposition inquiry focuses upon whether the defendant was an unwary innocent or instead an unwary criminal who readily availed himself of the opportunity to perpetrate the crime. So merely advertising forced reset triggers, solvent traps on a GunBroker account might be a little bit of inducement, but there is no coercion, there is no threatening, there is no bargaining going on here. They are literally dangling these items out, and then the individual comes by predisposed to purchasing them and in fact purchase these items. This technically is not entrapment. Let me give you another example that we see quite frequently. Oftentimes in buy-bust operations, law enforcement will act as if they're drug dealers. Now, if you're down on the street as an undercover officer offering to sell drugs, and you're merely just making an announcement to sell drugs, and somebody walks up to buy drugs from you, that is not entrapment. Why? Because you cannot prove that that person was not predisposed to purchasing the drugs. The minute they were invited to do so, they in fact did so. Now, if the undercover officer is trying to beg, plead, coerce them, do something, threaten them into purchasing the drugs, and now they want to prosecute them for possessing those drugs, that would be entrapment. Now, unlike on the federal level, where there is no statutory definition of entrapment, so we're basing it on our common law understanding of what entrapment was, which is the government's inducement to entice a person to commit criminal activity who otherwise was not predisposed to committing that act for the sake of prosecuting them. But in Washington State, for my Washington viewers, we actually have a statutory defense in the RCWs for entrapment. That statute is found in RCW 9A.16.070, and that statute specifically reads, in any prosecution for a crime, it is a defense that, A, the criminal design originated in the mind of law enforcement officials or any person acting under their direction, and B, the actor was lured or induced to commit a crime which the actor had not otherwise intended to commit. And then the statute makes perfectly clear in subsection 2, the defense of entrapment is not established by a showing only that law enforcement officials merely afforded the actor an opportunity to commit a crime. And while I am very critical of the Washington State Legislature for how they draft most statutes, I actually think that this statute is pretty well drafted and provides you with a roadmap for what the quantum of proof really is necessary in order to establish a valid affirmative defense of entrapment. So hypothetically, what if the ATF were out there with accounts advertising forced reset triggers, advertising wide open triggers, advertising solvent traps, and people are out there finding these accounts and willingly buying from that? Does that constitute entrapment? No, it does not. Listen, you may have more questions about anything related to entrapment or anything else related to your Second Amendment rights, and if you do, don't ever hesitate to contact us at WashingtonGunLaw.com, or of course you can call us directly at 425-765-0487. Now, let's remember, part of being the lawful and responsible gun owner is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.